everyone. Thank you very much for following us online today. And today we have pleasure to invite Professor Katharina Pistor from Columbia Law School. And he is also the author of the Code of Capital. So this is the traditional Chinese version, and I believe the simplified Chinese version will be also coming soon. So really appreciate for your valuable time today, given as we know it is late evening in the United States. So really appreciate for joining us today. So today we will briefly talk about the Code of Capital, this topic, and Professor Katharina will make the presentation around 30 to 40 minutes. And after that, that will be the discussion time. So also thank you for those of audience contributing your question, and we will select some of interesting question and bring to the webinar. So Professor Katharina, if you are ready, the floor is yours.
Thank you. I am ready. Let me just share my screen with you so I can show you my slides here. So this is just the cover page that I got from you. You can see the English language version here in the upper right-hand corner, and you already showed the complex Chinese version, which came out a couple of weeks ago. We're looking forward to the Chinese version, to the simple Chinese version that is in the making as well. I know that also Princeton University Press is here today with us, and I really appreciate all their support. So let me say a few words about the core thesis of the book and then introduce some of the applications. I very welcome questions later about parts of the book that I won't be able to get to, but let me just try to give you a general overview. So the fundamental question, of course, that I'm asking in a book that has capital in its title is what is capital and what creates capital assets? And I'm basically defining capital as a wealth generating asset. So I'm not going back to some of the economists who are saying capital is one of the factors of production, labor is the other, and who are thinking mostly as capital as a physical input. But I'm basically saying what capital has the capacity to do is to generate and to protect wealth. So then that raises the question, how can capital do that? And I'm basically saying it does that because it has a legal code. Think of the genetic code or think of the software code that basically carries the information, the ingredients for turning a simple asset, let's say land, or a promise to pay, or an idea, into a wealth generating asset. And here on this first slide, I have listed the attributes, the qualities that turn a simple asset into a capital asset. The four attributes that I list here are all important. You don't need all four to turn a simple asset into a capital asset, but you need typically 3 out of these 4. So let me briefly explain what they do. The first one is priority, which basically says we rank legal rights that some holders or some interested parties to an asset have vis-a-vis others. So some have stronger rights, others have weaker rights. If you have stronger rights, you're typically better off. And the test case for how strong your rights really are is typically the default of a debtor. So a bankruptcy or insolvency scenario, when multiple creditors are trying to enforce against a pool of asset that is less than the total volume of claims that are raised against these assets. So in that scenario, it's really important. If you have a strong right, you can fully enforce your rights against the assets. If you have a weak right, you only get a fraction of what you claimed. You get a steep haircut, as we say in the financial jargon. The second important attribute is durability, which basically extends rights in time and protects rights of asset holders against too many other competing claims. The third attribute is universality, which basically means that we are protecting these rights not only vis-a-vis 2 parties who might have negotiated them, but against the world, against everyone, ergo omnes in Latinese that lawyers like to use. So universality really means that somehow a particular interest to an asset is protected against the world, not only vis-a-vis a contracting party. And then the final attribute, convertibility, applies mostly to financial assets and is in fact the way in which financial assets attain durability. Convertibility is not just tradability. It's not just about the assignment of an asset to somebody else, but it's the right to flip your interest, your asset, into a different asset, and hopefully into a safer one. So you see this typically in financial crisis, that holders of assets fear that their assets might lose in their nominal, not only in their real and in their nominal value actually, and they're trying to convert it into something else. And typically in the end of the day, they want to hold cash from a sovereign that can protect its own currency and at least protect the nominal value of your asset. What this does, basically, it allows you to lock in past gains. In good times, the nominal value is not so interesting. You want to increase the real value. In bad times, it gives you a lot of protection. So how do we do this? I'm basically saying, if you look back in history over the last 400 years or so, 500 years if you want, when the system that we call capitalism evolved, you can see that a relatively small set of institutions, mostly institutions that we would call private law institutions, have done most of the work in terms of coding certain assets as capital. I'm listing here 6. You can add more. There are other ways to do the same, but these are the most important ones in my judgment. The first is property law. Property law creates basically rights of an individual, or it could be also more parties, to a particular asset that are stronger than anybody else's rights. You can exclude others from the use of your asset. You can sell the asset. You can alienate it. Property is a very powerful right. And you see this again in bankruptcy, my asset test for the strength of rights that you have. Because if you own an asset that is in the possession of a debtor, when the debtor is bankrupt, you can take it out, and all the other creditors have to stand aside. The second legal institution that I'm listing here is collateral law, which is a kind of a property right. It gives you an interest against an asset that you can execute or enforce when your debtor defaults on a loan. So again, in bankruptcy, if you have a secured interest that is a collateral against certain assets, you can pull out these assets and enforce against them. Again, all the other creditors who have weaker rights have to stand aside. Then we have 2 legal institutions, or legal modules, as I call them in the book, that do a lot of the work in terms of durability. That's the common law trust. For those of you who have been trained in Hong Kong, they are familiar with that. It's an English law institution, common law trust, and the corporate law. What this basically does, it allows you to create a veil, a legal veil, a shield around a pool of assets and protect it from too many other claimants. That veil can be long-term, indefinite. Basically, most corporations that are created today don't have a life end, but they can operate forever. And the assets behind that corporate veil can grow and incubate for the entire period. So you can change shareholders, you can change management, you can change everything the corporation does exist and survive. You have to put it to death through a particular procedure, such as bankruptcy or voluntary liquidation. Bankruptcy is typically mandatory law, so it's somewhere a hybrid between private and public law, if you want, in a civil law thinking. But bankruptcy law also creates priority rights. It basically says in which order creditors can enforce against the assets of a debtor, or sometimes it exempts some creditors from certain operations of the bankruptcy law. Just think about the concept of bankruptcy safe harbors for repos and derivatives that many bankruptcy codes have adopted, especially in the run-up to the 2008 crisis. And last but not least, contract law is really the quintessential example of law that governs the relationship between 2 parties. But contract law goes beyond just the agreement between the parties. It makes this agreement enforceable. And through contractual arrangements, private parties can replicate and mimic many of the features of the other institutions that I discussed about already, especially in our age of information technology, where it's possible to contract with thousands, if not millions of people at very low cost, and thereby make contractual agreements effectively universal. So what is the role of law in all that? What I'm arguing basically is that these private law institutions that I mentioned before really work and owe their power to the fact that they're backed by the state. So the state basically has centralized the means of coercion, and private parties can piggyback on the means of coercion to organize their own relationships and rely on the state's powers if they want to enforce their interest against one another. So that's really important. So most lay people think of law as a top-down ordering device by which the state governs people on its territory. Sometimes you also think of citizens using the law against the state, such as in Western constitutional democracies, where the citizens can rely on civil and political rights, basically use a source of the state, the law, against the state itself, which is a really interesting concept, but can be quite powerful if these rights are fully enforced. What I'm talking about mostly in this book is not this vertical dimension, either top down or bottom up, but it's really a horizontal relationship between citizens or private parties, don't have to be citizens of the same country, that harness the powers of state law, and not necessarily only of their own state's law, to organize their relations with one another, whether it's property rights to land, whether it's firms, whether it's debt, or whether it's know-how. So here I'm just giving you the 4 classic assets that I analyze in the book, and I'm basically showing you over a course of a longer period how these assets have been coded as capital using the legal modules that I have mentioned before. So I start with land because everything starts with land. A legal historian, Bernard Rudden, who taught at Oxford for many years, he taught actually Soviet law and legal history. He wrote in an article in 1994 that the origins of property law, as we know it today, can be traced to the age of feudalism. But the core institutions that were invented yet today are not used primarily anymore to code land. That is the role they play as well, but they're also used to code financial assets. He's talking about funds that you can transfer by a click of the mouse, trillions of dollars worth in no time today. But underlying the structure are legal institutions that we have to understand. So you have to understand where property rights come from. To that, you have to go to land, and then you can show how the same institutions were transposed and used to also code financial interests as capital. Firms or business organizations are important assets or wealth-creating organizations, if you want. And of course, the history from simple partnerships, commercial entities, to corporations that own their own assets because they're called legal entities, legal persons, and can protect these assets against their shareholders, who can't just take them out, and of course against the personal creditors of these shareholders, which basically creates this incubator which they can hold for periods of time. Trusts, common law trust, also basically insulate a pool of assets that a trust settler transfers to this legal vehicle and appoints a trustee who manages these assets on behalf of a third party, the beneficiaries. Again, we're basically creating, through private law, a separation of interest to a particular assets where somebody has stronger rights to these assets than somebody else. And last but not least, of course, in our own age, in the knowledge society, know-how, that is intellectual property rights, have become really important. And again, I show what is the history of intellectual property rights, and how even things like our genetic code, the human code or the natural code, has been increasingly enclosed by legal mechanisms so that some have better rights to use and to exploit the natural code for their own benefits. So in the book, you would find a chapter each on land, firms, debt, and know-how. For the presentation tonight or this morning for you in Asia, I'm focusing on land and I'm focusing on debt, but I'd be more than happy to respond to questions about the other topics. So everything starts, as Bernard Rodden said, with the age of feudalism and land, and of course in England in the 16th century with the enclosure of land. Because prior to the end of the 16th century, it wasn't so clear who had the strongest right to land. There was no code, there was no land registry. It was actually not clear in terms of formal legal principles. They were just centuries-old use practices. And at some point, the landlords decided to exclude the commoners from access to the land because they wanted to use the land to herd sheep and use the wool from the sheep to put them into the factories to make more money or to grow cash crops. And so they enclosed the land, they built fences and they built hedges. And then the commoners said, you can't do this, we have access to the land. So they broke the fences and they broke the hedges. In the end, they had to settle their dispute in court. And it took about 100 to 150 years for multiple thousands really of individual lawsuits to be settled. And in the end, the landlords' arguments won. We can go into why that was, but basically they were saying, we've always had the better right. Only for some time we granted rights to the commoners. We're now taking them back, and the courts backed that decision. So they asserted priority because of seniority. Right. Now, when you take the enclosure of land to the colonies that English settlers created in North America, in New Zealand, Australia, and elsewhere, there, of course, they confronted indigenous people. So they were not first. They couldn't say seniority. They used a different argument. And that argument was a mixture of discovery, that was the territorial claim of the sovereign, of the crown, and improvement. So whoever improves the land can claim title to the land. This is part of John Locke's justification for property rights, that if you combine your labor with an asset, you should have a property right in that asset. But we should also remind ourselves that at the time that John Locke formulated this principle, he was a British official in the North American colony and was justifying the settlers' property rights to the land vis-a-vis the indigenous people, the first people in America as well. So the legal arguments can shift, but the principle remains the same. Somebody asserts priority and can enforce these priority rights only with the backing of the state. Courts were erected in North America, there were judges who were basically enforcing it, and of course you have, if necessary, the troops to enforce against the indigenous people. So what is interesting though, that once you have coded land and you're giving property rights to an owner, that owner can use that property and right and monetize it, which is what many development economists want to happen. Adnan de Soto, for example, has advertised giving title to squatters and others so they can monetize their property rights, get a loan, give their land as a collateral, get lower cost access to credit, and then basically bootstrap themselves out of poverty by building a business. The problem of this model is that if something doesn't work out, you can lose everything because the creditors have then the right to seize the land. The English landlords who realized that used another legal device to protect their interest in the land. They entailed the land, as it was called. They basically created a trust-like legal vehicle around the land and said, the current owner is not really the full owner, he's only the life tenant who holds the property on behalf of future generations. And that lasted actually until the end of the 19th century. So until 1881, England had a really feudalistic type of land ownership system. After a major crisis in agriculture, they completely reformed the land and treated land as chattel. And then you can see what happened. Let me just show you here a picture of, this is from Piketty's, Thomas Piketty's book on capital in the 21st century that many of you might have read. And he has a chapter where he talks about the metamorphosis of capital and shows here that the big black block here at the bottom is rural land, agricultural land. And you see the kink that really breaks down in 1881. That's when land was put on the auction block because it was no longer protected by a legal device. That's my explanation, not Piketty's, that's my explanation. It was no longer protected by a legal device and just became a simple asset in the sense that there were still property rights to land, but it lost durability. And other assets became more important, but they were also then coded in a very similar way in which land had been coded before. Now, what is interesting when you look to the United States, you see that the relative importance of agriculture or rural land has declined in the US much earlier. And there's a good reason for that, because the same English Parliament that would not reform property rights in England reformed property rights in North America, because in North America, they were the creditors. They wanted to seize the land of debtors who didn't pay. And so they enacted in 1732 the Debt Recovery Act in North America, which allowed them to enforce against families, even take their family mansion, and enforce against one of the most important collateral that they used, which were human slaves. That actually triggered the first slave auctions in North America. So my argument, so Piketty, when he looks at these data, he says there's a change in supply and demand, there's technological change. And I'm basically saying, if you look just a little deeper below the surface, you find a code. Just like when we look at a biological organism, if you look a little deeper, you find a genetic code. You find the information that actually protects certain assets and thereby gives them a greater propensity to be capital, to be a wealth generating asset than if they didn't have that. Okay, let me just move on to the next type of asset that I wanted to discuss, which is debt. So debt, of course, is at first glance only a simple contractual promise to payment in the future. But as you know, nowadays we are trading debt as if it was a thing, right? These are assets that we're trading on a global market. And we have also found ways to create new types of assets out of debt, which are asset-backed securities. So I just want to walk you briefly through this little slide, which shows you effectively how land, again, we're back to land, was securitized. How you can, with legal devices, use a claim against the land, securitize it, sell interest against the securitization structure, which is actually a trust, to investors, which included in this case the China Investment Corporation, a sovereign wealth fund, sorry. This is the slide I want to show you, or a German Landesbank, a state-owned regional bank in Germany, or BNP Paribas, or many other international investors. But let me start from here. In the left-hand corner, you have little houses in California. You have a mortgage originator, New Century, that gives loans to homeowners, and the homeowners give a mortgage in their land to secure the loan. New Century does this thousands of times, bundles all these loans backed by mortgages and sells them wholesale to Citigroup. Within Citigroup, there are multiple entities, so this is a big simplification. One of the entities within Citigroup in New York, now we're no longer in California, we're now in New York, takes them and throws them into a trust. Why? Because they want to sell interest against the trust to investors and assure these investors that they don't have to worry about the standing of Citi, the credit risk of Citi. All they have to think about is the credit risk of the assets in the pool. That is the loans that the homeowners pay back into this pool. And since there are thousands of them, even if one defaults, there's still a lot of cash flow. So most investors will get some money and they never have to think about Citi. What they then did, they tranched the cash flow interest into the trust. And if you were a senior investor, such as Fannie Mae, you would get the first cash flow and you would basically have to suffer losses only at the very end. If you're a junior investor, then you have exactly the opposite risk. And so you can see here the senior tranches went to Fannie Mae, China Investment Corporation, Bayerische Landesbank, etc. One of the big problems, however, in the securitization structure was that the mezzanine tranches, which were not risky enough to give you high yield and too risky for the safe investors, they were difficult to place. And if you can't place all the tranches in the securitization structure, the whole machine doesn't really work. And so to solve that problem, the industry invented collateralized debt obligations, which is basically another legal structure. You take a corporation that buys the mezzanine tranches from hundreds, if not thousands, of other securitization structures and sells them again to investors. This particular CDO is located in the Cayman Islands, so you get not only a corporate structure, you get also tax benefits, and then you sell off interest into the future cash flow of this particular entity to investors. And if you get stuck again with your mezzanine tranches, you just do a CDO squared or a CDO cubed, and that's what they did. So basically what you start with land, property rights and land, you create a mortgage, which is a collateral, my other legal module. You put this behind a trust that creates durability, and then you basically sell interest against the trust to these different investors. For the CDO structure, you do the same thing. You take a legal vehicle, a corporate entity. So you separate that entity from other interests and then assure investors that they can buy the cash flow rights that go into that particular entity. So you can basically transform one of the most immovable assets, which is land, into a globally traded asset by using the cash flows that the land might generate and repackaging them through all these different legal schemes. And that's basically how we created an international market for assets, asset-backed securities, whether these assets were houses, whether they were car loans or other receivables. You can repackage and package the stuff all using the same mechanisms. Okay, so it's what the coding does to debt that makes it a tradable asset, an asset that you can use to generate wealth. I'm going to, I will say just mention here, because I want to just move on to globalization and the final chapter of the book. I just want to say a word here that I do discuss in the book, the question whether the digital code might replace the legal code. In the book, I come out saying that I think so far the signs are that the legal code might enclose and control the digital code, but I'm perhaps no longer quite as sure about this. So I'd be happy to entertain any questions that you might have later on this. But let me just say a word about globalization. You got a sense about globalization already in the debt example, in the securitization structures, because so many different entities bought assets against the securitization structure or against the CDO. And the interesting question, of course, that we have to ask ourselves, if you just go back to the slide, you know, what is it for, let's say, even a Chinese entity? How come this Chinese entity is sure that an interest that is basically created under New York law is a viable interest and enforceable elsewhere? And one of the arguments that I develop in the book is that our global system of capitalism is actually not supported by a global system of law or a global state. We all know that this doesn't exist. But what we have is a patchwork of different legal systems. You can see them here indicated by the different flags. This is New York. This is, of course, the United States, federal government, China, Germany, France, Cayman Island, and so forth. Switzerland, that's the underwriter, but you can add a lot of others. And this is why I have these little globes with all the flags here. This works because most countries have a set of rules that we call conflict of law rules that basically tell private parties that they can pick and choose the laws of different jurisdictions and create a patchwork of different legal systems for their transactions. And that even if they choose the laws of a different jurisdiction, this will be enforceable by the courts of a different country. So you can be in Switzerland and you can use a trust in New York and enforce the rights that emanate from that trust in Swiss courts, but under New York law. And you can get many more examples like that. So when I ask the question about the code for the globe, I'm basically saying, in theory, we could have a global system of capitalism that is sustained only by one legal system, as long as all other domestic legal systems recognize and are willing to enforce the rights that you can create under that legal system. In fact, we have a global system of capitalism that is dominated by two legal systems, English law and US law, in particular for the private law institutions I'm interested in, the laws of the state of New York and the laws of Delaware for corporate law. These legal systems have been most accommodating for the interests of private capital holders, and many investors from other jurisdictions choose those legal systems. They're also advised, I will say a word about this, to do so by lawyers. And this works because most other countries will recognize and enforce the rights created in these legal systems for all of the most relevant entitlements that you can think of. So we know, of course, that London and New York are still the most important global financial center. They have competitors. There's Hong Kong, there's Singapore, there's Shenzhen. So this is not, cast in stone. This can change over time, but they still remain the most important financial centers. What people talk about less is that these two legal cities are also the home of the top global law firms. And when you take a list, this is a little dated now, 2018, and I give you only the top 20 lists, but if you push this down to the 100 global firms, top global firms in the world, which means law firms that have offices in more than one national jurisdiction, you find almost exclusively English names, either American firms or English firms. And that reflects that most of the coding of capital, of international, of global capital is happening in London and in New York by lawyers who were trained in English or American law. So then the final thing I want to say is, how does all that work out with our systems of self-governance that we have created at the national level? So there's, of course, the American institution that is the oldest constitution in the world and is fragile under enormous pressure, as we all know, as we're watching the elections of this year in particular. But the aspiration is that we, the people, govern ourselves. And how do we, the people, govern ourselves? We govern ourselves through law, the constitution, legislation. The Constitution of the People's Republic of China also says all power in the People's Republic of China belongs to the people. And the National People's Congress and the local People's Congresses at various levels are the organs through which the people exercise state power. However you want to interpret this in real life, what you should realize after my presentation is that a lot of power is exercised not through the legislatures at whatever level of government, but a lot of power is exercised by private parties with savvy lawyers at their side, knowing private law institutions, using them to code assets and enforcing them against the world. So I think I should probably stop here. Let me just say that, especially if you're thinking about democratic self-governance, this poses enormous challenge about how we want to govern ourselves in the future. And I have some comments in the back of the book in the final chapters where I'm discussing what we need to do to retain the ability to self-govern, especially if we have the ambition to self-govern in a democratic fashion. But let me just stop here and hear your comments and questions.
Okay, thank you, Professor Pistor, for your very comprehensive presentation and a very informative to give us the landscape in terms of the different perspective to see the code of capital. I think that is very interesting from the land and to the depth. And I think in your book, you're also addressing intellectual property and also the digital currency, where that in 2020, a lot of government and also jurisdiction, they were thinking how to adopt the digital central bank digital currency to their country. So I think that is very interesting topic and very timely to have this discussion. So as you know, that we also collect the question from the audience So here we collect 10 questions, but before we address, maybe we are not going to address the 10 questions, but before we address the question from the audience, maybe let me start by some of my prepared question and to get your perspective on that. So as we observe maybe in the last 3-5 years, a lot of we call the disruptive innovation, for example, Uber and also fintech. A lot of like maybe in many countries when those like the new industry they come into this market, what they are going to do is not maybe first to find out the legal perspective, and maybe what they want to do is like when they are very small, let regulator they don't care. But when they grow up very big, they say we are already here, and if you regulate us, if you have any regulation, that will have a strong impact for many people's career. So what do you think the paradigm of this? Because it seems to me the disruptive innovation is very good for society, but on the other hand side, it also seems to me when we talk about the law for today's topic, it seems they are not, they are pushing laws in maybe amendment. So what do you think on that?
So the way I look at Uber or Lyft or many of these other disruptive or innovative startups is that they are not only have great technological innovation, but they also have very sophisticated lawyers on their side. Take the example of Uber. You could imagine Uber to be run by a taxi cooperative where the taxi drivers organize themselves, take an app, and then you can call the taxi drivers on the street and they pick you up. Right? But it's not a cooperative. It is a corporation backed by capital where shareholders have made tons of money. And they have in part made tons of money by arbitraging around labor rules, labor law, right? Because they're treating their drivers as independent contractors rather than employees. And so they're not subject to all the mandatory requirements under labor law. So part of the success of Uber, not the idea itself, the idea is a great idea. And it was not picked up by a co-op, I say that. But Uber would have never become as successful had they not found a way to arbitrage around existing rules. That's part of the story. By the way, it's a corporation. It's a publicly traded corporation. It uses a corporate law. It uses shareholder rights. It chooses the jurisdiction where it wants to be incorporated. It uses every element in my textbook about the code of capital and then combines it with a new idea. So these new technological disruptions don't happen outside the law. They work only because they too benefit from the enforceability of the rights they create. And then they're enormously innovative by trying to arbitrage around existing rules and regulations.
Right, right. Thank you very much. And I think that is very interesting because a few months ago, I was in Chinese University of Hong Kong. And one of my friend, Professor David Donut, he is also working on the project and to compare the continental law, the German law, and also the British law, because in most case law country, I think when in the court that lawyer and the judge have more discussion, and that could be the case for the future cases. And but for maybe the German law, maybe what we can do is that for those people want to influence law, they need to go to the legislator to lobby them. So what do you think that the difference between the cash law and also the civil law?
So I think, there's a big debate, of course, about the difference between civil law and common law. And I think there is a real important difference. In my view, the most important difference is actually the relative power of the private legal profession. And they're much more powerful under the common law, in part because the private legal profession is much older, but also in part because of the judges who sit on the courts in common law countries are recruited from the private legal profession. In contrast, in the civil law jurisdictions, you have judges who are directly coming from law school with some special training programs, sometimes directly for judges or for prosecutors for that matter, but they don't come from the private legal profession. So they're more bureaucrats and they look at the law in a different way. So the power of the common law is actually the amount of flexibility and power given to private parties and their lawyers to fashion new rights out of the common law and enforce them against others. That's an enormously powerful tool, and it works much easier, much more smoothly in the common law context than in civil law jurisdictions.
Professor Pistor. So the next question is that we saw from your book that you talk the code of capital, this concept in different maybe perspective and in different category. So my next question is maybe from the time landscape. If we look back in the historical perspective, as you mentioned, maybe the status, how people implement or how people follow the regulation is also different. So as we know that maybe in China, when we look back maybe 50 years or 100 years, 200 years, even we have regulation, but we have one phrase called local emperor, which means even the central government have regulation, but because of the implementation, it's very hard to exist in the local authority. For example, the central authority is in Beijing, but if that another county is in very far from Beijing, even we have regulation, it's very hard to implementation. So that's why we call it as local emperor. So what do you think about that? Because now we see that artificial intelligence, big data is quite a lot of implementation in our daily life. So maybe before, let's take, for example, when we maybe break the traffic rule, when we cross the road without the green light, maybe we don't, in some times we don't care because nobody will catch that. But maybe in China, in Shanghai, sometimes they now have the experiment to adopt those devices and to track when people passing through the road, whether they follow the light. So my question is that we see that AI and a lot of like IoT, Internet of Things, that is happened in our daily life. So what do you think that the law or as the big system that will be changing or transforming in the next 10 years or 30 years?
Yeah, that's a very good question. So I think we could push the question that I ask in the book a little further in terms of whether the digital code, the control over data, that either governments or private entities or combination of both can exert over us, whether this might actually replace the legal code. And I think it's a serious threat, and I take it even more seriously than I did when I wrote the book. For a number of reasons. So the examples that you give of China is basically central government harnessing the technology of the information technology age for entrenching its own central powers. And given the capacity of the digital code, it can do this in a highly sophisticated manner. But we should not be afraid only of governments. We should also be afraid of private actors, whether it's the Googles, the Facebooks, the Amazons of this world, who also control us, and they use us for commercial gain, but also in part to manipulate us. So I think we're living through a transformation where we're no longer sure actually what it means to have a free decision about what we want to buy or not to buy, or where we want to go, whether we have access to credit or whether we have access to government services. It will be increasingly determined by behavioral data that have been harvested about us without necessarily our consent. So I think I'm very concerned about this development at every level, not only the central government level, also by the private level, because I think the private entities are attaining quasi-sovereign power over us as well. And so it's a space that we certainly have to watch, and we have to think about whether we can still control it with our good old measures with legal constraints. before it's too late.
Okay, thank you, Professor Pistor. So the final question from myself is that in your presentation, you're addressing the globalization. But we also see a lot of the phenomenon of deglobalization, for example, protectionism or anti-migration. So in that sense, what do you think that the deglobalization, the trend for deglobalization will change that what happened for globalization in the last 20 to 30 years?
Yeah, I mean, I think it's a very good question. So as I describe it in my book, globalization is really made possible by legal systems, whereby domestic legal systems have accepted to enforce foreign law and have allowed their own private entities to opt out of their own domestic legal systems and use foreign law, if this is more interesting for that. I actually argue in the book that we have allowed this to go too far, which doesn't mean that we should go back to a protectionist, nationalist kind of backlash. But we certainly have allowed sophisticated actors to pick and choose law as if it was a commodity. And law is a social good, it's not a private good. And I think the discontent and the political backlash that we're seeing today is also can be explained by the fact that most people have realized that they no longer have control over their own future. They can't govern themselves anymore because too many decisions are taken out of their hands and they have been delegated to others. So I think we should protect global trade. I'm much more skeptical about the opening of borders for global capital flow. And I think the IMF is going there as well. And these are all legal measures. We can attune this. We don't have to, it's not a switch on or off, globalization or deglobalization. But the question is on what measures and what kind of issues can we be comfortable with people choosing and picking and choosing their laws. So we can open our borders not only to goods, but also to different legal systems. And on what issues should we not do this? Because we want to set the norms to govern ourselves in our own countries as democratic constituencies.
Okay, thank you very much, Professor Pistor. So maybe let's turn to the question from the audience. So the first one we get from maybe that we want to address is, hi, Professor, I'm an undergraduate student in Lancaster University at the United Kingdom. My question is, what do you think about the relationship between laws and the increasing of global capital? Because laws sometimes will limit the scale of capital. Do you agree with this argument?
Well, I think my argument is that capital is actually coded in law. So without law, capital would not exist. Now, we can, of course, also constrain the way in which certain assets are being used. And we do this through regulations. Also, we constrain behavior. In that sense, of course, it is ambiguous. You can either support it and enable capital, and you can also restrain it. My core argument about globalization is that because capital holders can pick and choose the law that they use to code capital, they can relatively easily get around the constraints. And I think to some extent, we have probably pushed it too far and made it too easy for people to pick and choose the laws by which they code capital, whether it's Cayman Island or whether it's English law or whether it's Dutch law, even if they do business elsewhere, and thereby undermine the capacity of other polities to govern themselves.
Right. Thank you very much. For follow that question, I think there is one question maybe associated with the previous one. So if everyone were as familiar with the law as a lawyer, would it improve the gap between the rich and the poor? Of course, I think that could not be happen in reality, but I think that will be interesting to address.
It's a great question. I think there is truth to it. Just imagine that there's so many businesses still run as simple partnerships, where the people who run the business risk to lose everything, including all their personal wealth if the business goes under. So if they had access to a lawyer who could tell them how to incorporate a business, who can separate the assets of the firm from their own asset, they would already be better off. And many of the sophisticated tools that rich people use to hide their assets from tax authorities, now the poor will never have the same gain from that because they don't have enough wealth, but we could at least help them with the law to protect themselves from uncontrollable events in the future, relatively speaking. Never absolutely, but we could do better than we currently do. So yes, better access to the law would help.
Right, right. Thank you very much. So I think that will be really encourage maybe a lot of audience to think about to study law for their bachelor.
Yeah.
Okay, so the next question is, we talk about the code of capital and also how it leads to rich and also inequalities. So the question here is from one of the also professor in law, Mr. Zheng, Dr. Zheng Yuerui. So if the law is tend to protect the capital, so what make it happen? Will that because of the market, the need from the market, the demand from the market, or it is because of the choice of legislator or regulator?
Well, I think the story that it can be both, to be straightforward. It can be both, but in most cases, capital is coded by private attorneys who advise private clients, and these attorneys are very much aware of public regulation, which they shall not violate because then whatever they do will not work. But they're also aware of how you can use collateral law, property law, trust law, corporate law, contract law to devise assets that give their clients better rights over everybody else. So I think the core of how you code capital is really private law, but in the expectation that whatever you create is enforceable. And whether or not something is enforceable is determined not only by the private law, but also by regulations. So lawyers have to know how to navigate around the constraints of existing regulation. They have to do both. But it's not the market as such, because the market functions only with law. You can't trade anything that is not a property right. You can't trade debt interest if you don't know that it's enforceable, right? So the law comes first and is absolutely critical.
Right, right. Thank you very much, Professor Pistor. And the next question is from Mr. He Jianhua. So the question is, do you think that the law, when it make the society maybe in equalities status, do you think that is the law make the status of people, they cannot change in the very beginning, or because of that the law may be limited the transaction between parties? So I think that his question is maybe, do you think that the law is like limited the activity, like the dynamic, or maybe that will affect maybe when people just get born and his destiny already be decided?
Well, I think one of the interesting, inventions that we made as human societies, you can see this very explicitly in the French Civil Code, is that once you're born, we actually say that you've become sort of, you have legal rights. You get legal rights when you are born, and then you exercise these legal rights. Now, most countries today give, in theory, at a formal level, everybody the same legal rights. But whether or not you inherit a lot of property from your ancestors, or whether or not you're born in a family that can afford you an education that gives you access to opportunities and ultimately lawyers who help you protect your wealth, that's a very different matter. So I think we don't have a system nowadays, but we've used to have this feudalism. You were determined by your status, right? And we have seen then over a course of 200 or 300 years, we moved from status, legal protections or legal rules that protected a status, to legal rules that protect a contract. So the game today is mostly about, do I have better access to the legal elements, the modules of the code that I can use to produce wealth? It's not predetermined at birth. No, it's no longer.
Right, right. And I think a lot of questions from the audience here is really want to maybe compare the socialism and also capitalism, and how does it transit? Because some of the audience also say, as Karl Marx mentioned in his publication, that he also mentioned that capitalism eventually will go to the socialism. Of course, I'm not really the big fan of that, but I just think about maybe from your point of view, based on your research, what do you think about that? Because it seems to me that the code of capital, is it, maybe my question here is that, is it because of the capitalism and make that happen, and the law leads to inequalities? And the second question, what do you think the law's meaning to both socialism and also capitalism?
Well, I think, yeah, great question. So you could imagine that the state would have backed very different rights than it ultimately backed. So when I go back to the enclosure of land in England, it would have been possible in theory that the courts would have come out and protected the rights of the commoners. So the law as such didn't determine it, but a certain interpretation of the law. And of course, in order to understand that, you have to bring in power relations. And, Karl Marx said capital is a social relation. He was mostly focusing on the ownership of the means of production and the relationship to labor, and said the surplus that the capitalists extract is basically from labor. What I'm arguing in the book is that this is too narrow. Marx is right that capitalism is a social relationship. But the extraction of surplus is not only from labor, but we can do this even without labor. Because if you have access to the powers of the state to code your own capital, you don't need labor to do so. And we are dispensing increasingly with labor. Whether capitalism will survive in the long term, I think it has been proven to be much more resilient than Marx thought it to be, because what Marx, I don't think, has fully anticipated is the willingness of the state to step in time and again in times of crisis and bail out the system, to socialize the costs of capitalism, and to allow the privatization of gains to continue. How much longer we were going to do this, I don't know, but I think it has happened for a much longer period than Marx had envisioned.
Right. Thank you, Professor Pistor. And I think that one of the interesting point also maybe addressing in your book is about the cryptocurrency and also the blockchain. So as we know, the central bank digital currency is like well discussed or widely discussed in many countries. And in China here, we also give it a try in Shenzhen. Let some certain area they can start using central bank digital currency. So from the currency perspective, what do you think that will mean to the code of capital? Because when people talk about the central bank digital currency, it leads to efficient, it leads to transparency, but it also leads to the privacy and also the conflict between the government and the citizen. And also last week, I also have the discussion with Professor Mauro from Wharton Business School to talk about 2030 in terms of cryptocurrency. So I think that will be very interesting to get your perspective, given that you show the landscape from both vertical and also horizontal.
Yes, thank you. Yeah, I think for me, the interesting battle that's unfolding right now is actually whether central banks will issue digital currencies, and if so, in what fashion, whether they basically replicate the system that we have, continue with private intermediaries, and just basically digitize more than they have already digitized. A lot of the money systems, of course, or payment systems are already digitized anyhow, or whether we see two alternatives. One is that the central banks do away with the middleman and control, basically we all open our accounts with central banks, which means that the central banks could also help us out in times of crisis, but they also might have direct information about us, and they would have to take over a lot of the functionalities that intermediaries do. But there's a third possibility as well, namely that you get private entities that issue currencies as competitors to state-issued currencies. And one of the most aggressive moves was last year with the Libra, when Facebook announced the launch of the Libra, against which I immediately wrote an op-ed and called for a stop of that. And I also appeared as a witness in the House of Representatives Financial Services Committee arguing against that. Why? Because I think what they were trying to do is to create a global currency. They were piggybacking on state structures, including the safety systems that the US and other countries have created, but created a currency for private gain. So I think we have multiple concerns here. We have the monopolization of the gains, the seigniorage that comes with the currency without taking the losses on, which I think is the model that Libra was pursuing. We have central banks that could, on the one hand, offer, again, a public service by making sure that there is a payment system, the currency that we can rely on, but we would also be exposed to greater scrutiny and privacy concerns by the government that controls that currency. Or we could have a continuation of what we have currently, which is not an ideal system either, where the central banks basically use financial intermediaries who then issue their own private money, but always on the condition that they can convert it back into state money. And of course, that creates an inherently fragile system. So in theory, I think we have a technology that would allow us to do much better. But as always in human history, is how we use the technology, whether it's the digital technology or the legal technology. And for whose purpose, for what ends, how do we normatively justify what we're doing? And can we actually govern ourselves? Can we govern those who use the systems in such a way that we are advancing the social good rather than only private good? That's the fundamental question.
Right, thank you. So may we add one more question?
Please. Mm-hmm.
Okay, sure. So I think this is very interesting question because that as we are experiencing the COVID-19 in 2020, and a lot of things is changing, transforming, and the paradigm is being redesigned. So the question from the audience is, what do you think that the COVID-19 will that accelerate the phenomenon you're addressing in your book, or will that have some different effect for those phenomena addressing in your book? What do you think about that?
Yeah, it's a great question. So I think what COVID does, it basically reinforces or brings to the open, really, the structures that we have created in law. So the inequalities that have been created, where some have stronger rights and others have weaker rights, get reinforced by a crisis like COVID, right? The question here is we have debtors and we have creditors. And we have central banks, and the central banks decide that somebody gets bailed out and somebody else does not get bailed out. And amongst the creditors and the debtors, we have to decide against whom do we enforce no matter what the costs. Are we evicting everybody who can't pay their rents? Are we denying people healthcare who can't afford healthcare? Are we basically trying to bail out the airlines when they have to fire their employees because there are not enough people are flying around? So we have created a private legal system where people have relied on the ability to govern the future, basically through private arrangements. It's your fault and you have to pay. And we're always trying to shift the risk of dealing with future uncertainty to the other party. But when a system implodes or receives an exogenous shock, which COVID truly is in many ways, at least to the legal system that we have created, then these things create a lot of stress. And the question is, do we relax the stress? Who does it? Who benefits? And who loses from that? And so I think, again, we have to intervene in existing contracts. We can't just let these contracts run their course because the event is a shock. We have actually institutions like force majeure, an unforeseen event where we would actually relax contracts. We have to do this across the board and then think about how to allocate the losses to those who are most likely to be able to deal with them.
Right. Thank you very much, Professor Pistor. We enjoy this 60 minutes webinar with you. And thank you very much for bringing us your insight and also your response to those audience questions. So really appreciate. And I hope that we have pleasure to host you in the future in Zhejiang University, the city we located, Hangzhou in China in the future, and maybe somewhere in the world in the future.
Thank you so much. It was a great pleasure to join you tonight or in the morning at your time. Thanks for all the great questions and for listening.
Right. Thank you very much and have a good night.
Yes, good morning for you. Bye-bye.
Okay, bye.